Everybody, welcome. It's so great to have you all here and great to have everyone watching online as well. I'm David DeCoste from the Markkula Center for Applied Ethics. We're really delighted to be co-sponsoring this with Santa Clara University School of Law. Just a brief note, you see the index cards in front of you. Please, as we're going, if you have questions you would like to have posed to Judge Fogel, if you could write those questions on the cards, we'll collect them. After a conversation between Professor Jundeff and Judge Fogel, we will have time for questions from the audience. So if you can write your questions and pass them down at the end of the aisle, and we'll go around and pick them up and try to get as many in the mix as possible. So to introduce our speakers today, I would like to introduce Dean Michael Kaufman of the Santa Clara University School of Law.
Thanks, Andrew. Thanks so much, David. Good afternoon, everybody. Good to see you. As David mentioned, my name is Michael Kaufman, and I have the honor of serving as the 16th Dean in the 112-year storied history of Santa Clara University School of Law. Welcome, one and all, to this very special program involving ethics on our judiciary. As you know, this topic is incredibly timeless, but also timely. It's timeless in that it goes back to about 346 AD, when we developed a maxim that no person should be a judge in their own cause. So we have a timeless conversation today about what it means to be a judge and whether or not a judge can be a judge in their own cause. But we also have a very timely conversation, ripped from the headlines, in fact. We gathered today at a time when only 37% of Americans have confidence in our court systems, an all-time low. It was a 50-year low. And part of that probably is due to the content of decisions, but also most of it due to the sense in which there are questions about the ethics surrounding our Supreme Court justices, of course, and also the court system as a whole. So we have a very timely and timeless conversation, and I can't imagine two better experts to lead us through that conversation than we have here gathered today. My colleague, Brad Jundeff, will help us in the conversation. Brad began on the faculty here in the year 2000. For 23 years, he's taught constitutional law and ethics and federalism and judging. He has the beauty of being an incredibly beloved colleague, a renowned and productive scholar, and also a public servant, but also the experience of serving as a clerk for Justice Sandra Day O'Connor on the Supreme Court. Has tremendous insight into what it means to be a jurist at the highest level. So Brad, thank you for being here. And then, of course, we are really blessed to be joined today by the leading light in the area, the nation's leading light in the area of ethics for judges, Judge Fogel, who is now the executive director of the Berkeley Institute for Judiciary, having served at the Center for Judges in D.C. for about, 8 years? 7 years. And before that, of course, closer to home, he was a federal judge on the United States Court here in the Northern District of California for 11 years, I believe. In that regard, always distinguished himself as a judge of integrity, fairness, equity, and compassion to some extent. And has become really the expert in the nation on the issue of judging both timeless and timely issues at that. He has won many awards, including most recently an award for the Samuel Gates Award, recognizing him as being the epitome of professionalism, civility, judicial restraint, right, and compassion and integrity. So he knows from which he speaks, and he knows what it means to be a jurist of tremendous compassion, but also of ethics. I can't imagine, as I said, two better conversants for this conversation. So I'm going to turn it over to Brad Jundeff to lead the conversation with tremendous gratitude to Brad and to Judge Fogel, but also to our co-sponsors, the Markkula Center for Ethics. I see Don Hyder, Executive Director, here. Thanks, Don, for being here. Board members are here gathered. Thank you so much for your support. And thanks, of course, to David as well for arranging us to be here. But let me turn it over to Brad. Thank you all for coming. Enjoy the conversation.
Great. Thank you so much, Dean Kaufman. Thank you all for being here, both in person and online. It's really a privilege to be here up at the front of the room with Judge Fogel, who I've known and admired for many, many years, going back, I think, even into the Santa Clara County Superior Court before being on the Northern District of California. So maybe just to kick us off, you could just explain for us, to ground our conversation, What exactly is a judicial code of ethics? What is their function? What do they do?
Okay, it's a great question. Let me make sure you can hear me. Is this okay? Good. And Dean Kaufman, thank you. That was way too generous, but thanks so much for those kind words. Code of conduct is, you think of it as sort of an aspirational thing rather than a set of binding rules. It's not like, it's not like the vehicle code or something where if you run a red light you get a ticket. It's more, these are the things we expect of our judicial officers. These are the values and the kind of behavior and conduct we expect from our judicial officers. And so every state has a formal code of conduct. Every federal court, other than the Supreme Court, we're going to talk about that, but every federal court has a code of conduct. And it sets out the principles we expect judges to live by. So, the impartiality and lack of financial or other interest in cases, lack of bias, diligence, administrative competence, things like that. And they're all sort of laid out as aspirational values, and then examples are given of what you can do and what you can't do. And there are some things that are pretty obvious. You shouldn't hear a case where you have a financial interest, right? But then there are things that aren't as obvious, where how you carry yourself in the world, how you behave out in the community when you're not on the bench, how you behave when you're on the bench. I mean, all of that is in codes of conduct as these are the aspirations, these are the values that we look for in our judicial officers.
Mm-hmm. Now, as you mentioned, the Supreme Court currently does not operate under any such code of conduct. It is subject to a number of federal statutes, including the Ethics in Government Act, which includes requirements for financial disclosure. I believe there's some other statutes that also apply to Supreme Court justices. Maybe you could just explain, why is it that the Supreme Court is, as I understand it, the only court in the United States, the only judicial body in the entire United States that doesn't operate under a judicial ethics code authority?
Yeah, well, I'll start there, and then I want to back up and
Sure.
unpack what you just asked me. But the Supreme Court is different in the sense that it is the only court that's actually mentioned in the Constitution. Mm-hmm. It has constitutional status. So it's just like Congress, the presidency, and the executive branch, and the U.S. Supreme Court. That is the embodiment of the judicial branch. And then the Constitution gives Congress the right and the authority to create other judgeships. So every other federal judgeship is actually a creature of the legislative function. They create the inferior courts. And so the history of this is that nobody really objects to Congress saying, all right, all of the lower courts have to have codes of conduct and set up procedures for enforcement and breaches and so forth, because the lower courts wouldn't exist if Congress hadn't created them. The Supreme Court's different, and they see themselves as different in the sense that they don't concede that Congress really has the right to regulate them at all. They're an independent branch of government, and so other than providing for their budget, providing for facilities, buildings, things like that, those are things obviously that they depend on Congress for. But when you get into actual regulation, they zealously guard their independence, and so you need to make a distinction here. There's something I have described it as decisional independence, which is absolutely sacrosanct. I mean, Congress cannot. They can make laws, but they can't tell the Supreme Court how to decide cases. That ultimately the Supreme Court has the independence to interpret the law, determine what the law means, and make those decisions. So they're very, very zealous about protecting that. What's happened is that they also have this kind of institutional independence, where their concern is that if Congress gets too involved in regulating what they do institutionally, that's going to intrude on their decisional independence. So there was a move a number of years ago when there was a lot of hostility between the judiciary and Congress to create an inspector general's office in the executive branch to oversee the judiciary. Mm-hmm. And I was present at some discussions of that where the Chief Justice was present, where there were other leaders of the judiciary present. And I think there was this widespread sense that they can't do that. That it's even though it's an administrative function, that it would intrude too much on the ability of judges to make independent decisions. So there's this kind of real sense of wanting to protect the court's independence. So you have to see the ethics response of the Supreme Court through that lens. I'm not saying I agree with it. I'm just saying I think that's how they see it.
Mm-hmm.
So you mentioned two things. There's the Ethics in Government Act and the Code of Conduct. The Ethics in Government Act explicitly applies to the Supreme Court. I mean, it applies to everybody. I mean, I had to comply with that all of the years I was a federal judge. I had to file reports. They do it, and they comply with it. But they've always done that with the reservation that we're doing this voluntarily. We're not conceding that Congress has the authority to force us to file financial disclosure reports, but we agree that we will file those reports in the interests of transparency and good government and things like that. So it's interesting because this has come up a lot, and we'll talk about this in the context of some of the revelations about some of the justices. But there's required reporting under the Ethics in Government Act, and I think it's important to say that they've never acknowledged that Congress has the plenary authority to impose that on them. They just do it anyway. Now, with the Code of Conduct, they've taken a similar position. They're saying that the Code of Conduct is fine for what we call Article 3 courts that are created by Congress, but they are reluctant to accept the idea that somebody can impose a code of conduct on them. And so what they say instead, and the chief said this in his annual report in 2011, then they said it again, it was a statement that actually all 9 justices signed, saying that this year we do look at the code of conduct that applies to everybody else. We also look at treatises and other ethical authorities, and we consult all of these authorities in deciding whether what we're doing is ethical. Mm-hmm. And they don't explicate exactly how they do that, or what they pay attention to, or what the interplay of those things is. But they do say, we're not completely without ethical guidance. We just look at this set of authorities, and we're doing so voluntarily because we want to do the right thing. So that is their official position.
I see. Even though, if I'm remembering correctly, under Article 3, Congress has the authority to regulate the jurisdiction of the Supreme Court.
It does.
And so what is it? Yeah. Anyway.
No, it does. I mean, and it's never been tested, right? Mm-hmm. I mean, we've never been in a situation where Congress has said, all right, and I do not think it's going to happen given the current state of Congress. But I mean, let's say Congress decided to impose a very strict ethical framework for the Supreme Court. Let's say that you could actually get both houses to pass something like that. Whether the Supreme Court would find that unconstitutional or not is an open question. I don't know.
Mm-hmm. Okay.
Yeah.
So setting aside whether Congress could do it or how we would get there, which we could come back to. Why do you testified before the Senate Judiciary Committee that you thought it was very important that the Supreme Court have some transparent, publicly stated code that it was bound to live by? Maybe you could just share with all of us why you think that's so important, particularly at this moment.
Yeah, I think it's very important, and in fact, I feel even more strongly about that today than I did back in May when I testified. The courts are having a crisis of confidence, and by that I mean all of the courts in the country. I mean, if you look at the polling data, and Pew Research has done polls on this on a regular basis for years, the judicial branch used to be the most respected branch of government. Actually, it still is, but the numbers have gone from like 80% down to below 50, and they're falling fast. And what happens is that people in general, the public in general, doesn't distinguish courts. If the Supreme Court does something bad, if a Supreme Court justice is accused of doing something inappropriate, people don't distinguish between those judges or justices and the rest of the judges and justices. Mm-hmm. And so the entire judiciary suffers because there's a lack of confidence in the ethics of the people at the top. Now, I'm not going to weigh in on whether anybody did anything right or wrong. I've been very careful about that. But I think that when you have appearances that are as significant as the appearances you have here, and you don't have a code of conduct, you don't have any rules that anybody can understand, that's really not a good situation, because it leaves the impression that people can just do whatever they want. And when you have specific instances, and I'll just pick this just for illustration. I mean, if you have, Justice Thomas's socializing, or Justice Alito's complaint flights, or Justice Sotomayor's book sales, you don't have to be partisan about this. The point is, it ends up being seen through a lens of partisanship, because you don't have any rules. So you're criticizing Justice Thomas because you don't like his rulings, or you're criticizing Justice Sotomayor because you don't like her rulings, and it's not because actually here are the rules, and they violated those rules, which is fair game for criticism, I think, right? So, and there aren't any rules that are transparent. What you have is, and I said it in my testimony, and I'll say it here, it's a black box. So you look at, and I have great regard for the Chief Justice. I worked for him for 7 years, and I have a lot of respect for him. But I disagree with him that the having this hodgepodge of authorities really does the job in terms of public trust and confidence. What treatises? What codes of conduct? What other ethical authorities? And who's relying on what in which instance? And how is X question being looked at? And what authorities are being brought to bear to analyze that question?
Yeah.
And we don't know. And I think the lack of clarity is very, very damaging to public confidence in the courts.
Yeah. So, and just to fill in, Judge Fogel's referring to, if I'm remembering correctly, the addendum that the Chief Justice put to his letter declining to testify at the.
That's right. And what he did in that addendum is he reiterated what he had said in 2011 in his annual report, and all of the justices signed it, all 9. Mm-hmm. And there was some speculation at the time. Well, this is the position of all 9 justices. Mm-hmm. Well, we know that that's not the final word from all 9 justices, because at least 6 of them, and Justice Gorsuch came very close to the 10th Circuit Conference, but at least 6 of them have explicitly said we should have a code of conduct. And so it's sort of like 6.5, 7 are on record as saying that we should be more explicit than we are. I think what the document was, the addendum was this is something all 9 of them could agree to.
Right.
And they all said this is what we do, and here it is.
Descriptive of what practice.
Yeah.
So maybe digging into that a little further. Suppose that I'll just say, there's a lot of speculation that they're working on this right now inside the building, particularly in light of what a number of justices have said over the summer when they've gone off. They typically have a lot of speaking engagements over the summer, and they're at various law schools or universities, and in Q&A, this is usually where it comes out, Justice Barrett most recently, where they concede that they would be in favor of that, when asked, which suggests that there's some deliberation going on within the building. I'm curious, knowing as much as you do about all of these things, how would such a thing actually be enforceable? And what would be the mechanics in the event that, say, someone thinks that because one of the justices did something, they should recuse themselves from the upcoming income tax case, which it appears that some donors might have a real big interest in.
All right, this is a question that is not easily answered. So if you are a lower court judge, let's say I was in a situation where somebody was accusing me of violating the code of conduct, and they sought my recusal as a result, I would have an obligation to at least look at that initially and decide whether I should recuse or not. And if I didn't, then there's a procedure for having that reviewed by other judges. Mm-hmm. I mean, in some cases, it could go to a colleague on the same court. You could just say, take a look at this. Or if a party thought I had made the wrong decision, they could go to the Court of Appeals, mm-hmm. and they could be reviewed by a judge in a higher court. But there is a process for judicial review of these kinds of decisions. There's also a committee, an ethics committee of the and I'm talking about federal courts here, but it's similar in the state courts, where Code of Conduct Committee, where you can go for independent advice. They don't have any enforcement authority, but if I had a question, can I do this? Is this okay? I can get an answer, by somebody who actually knows something about it. And so you have that. And then if I do violate the code, and there's a concern that I may have committed misconduct by doing that, the circuit councils of each circuit have the ability to impose discipline. They can't remove you if you're an Article III judge, because the only way you can be removed is by impeachment. But you can get a public admonishment, you can get a private admonishment. I mean, there's various things that can be done if these kinds of things occur, or they can take cases away. Because so. But the Supreme Court doesn't have anything like that. I mean, they're completely self-policing, and they could adopt a code of conduct, and if they had no mechanism for having their decisions reviewed, you'd only really solved half the problem. I mean, I think it would still be better than what we have now. I mean, if they just say we're going to try to follow these rules, and these are the rules we're going to try to follow. I mean, I think that in and of itself, that transparency would be a step forward.
Yeah.
But I think I think they need something better than that. They need a way to review their own judgments. And it goes back to what the dean said. I mean, you shouldn't be the judge in your own case. And so some of these recusal decisions are, reasonable minds can differ. And so the idea is that you would have some way of reviewing them. It's not really enforcement in the sense that somebody could impose a sanction on you.
Yeah.
But at least you could have somebody look at it. And I submitted something to the court a number of months ago with an organization called CREW, which is a nonprofit that works in the ethics area. And there's maybe just have a reference panel. We just have 3 retired judges. I am not volunteering, but three retired judges of unimpeachable integrity, bipartisan, people who really are solid. And I can name some people I think would fit that description. And have them sort of be a review panel. And so if something comes up and it's a significant question, just run it by them, just see what they think. So that you're not just relying on your own inward judgment.
Yeah.
And so I'll just give a couple of examples. And again, I don't mean to weigh in on the merits of anything, but so Justice Alito was criticized for accepting a flight to a salmon fishing venue, and as somebody who actually had interest before the court, and so the question was whether that was okay or not. And what he said in his response to it, which actually was a pre-response that he put in the Wall Street Journal, he said, I would have decided the case the same way anyway. It didn't have any influence on me. And, I know Justice Alito, and I believe that is 100% true. I don't think it made any difference in terms of his jurisprudence or what he would have decided. But to me, the question there is not whether he would have decided the case the same way. The question is whether the appearance in and of itself was problematic, right? And you don't, at this point, you don't have any way of reviewing that. There's nothing that gives the court that opportunity. Now, a couple of the justices, and I'm going to, just because I think it's so important to be nonpartisan in this space. I mean, one of the best examples I've seen of a way to handle this was actually Justice Scalia. And if you remember the Dick Cheney, the duck hunting, right?
Sure.
It goes duck hunting with then Vice President Cheney, and then Cheney shows up as a defendant in his official capacity in a court in a case before this report, and Justice Scalia didn't recuse himself. What he did, though, is he actually wrote a explanation as to why he wasn't recusing himself, and it was several pages in length. And he really took the time to delve into the reasons why he didn't recuse. And agree or disagree, the thing that was good about it, and what I think was a positive thing he did, was he provided transparency. That instead of it just being, I'm a Supreme Court justice, I don't have to do that.
Yeah.
He said, I am a Supreme Court justice. I realize that a question's been raised. Here's why I answered the question the way I did. And I think it was a very positive thing for him to do. Justice Kagan now when she recuses, and she has various reasons to recuse because she was Solicitor General and she was the Dean at Harvard Law School and various things, she always explains why she's recusing, and it might be 2 sentences, but it's never just I'm recusing myself. She explains why she's recusing. And I think that transparency is very helpful.
Right. And just one quick thing, if I can follow up on that. With the Supreme Court, there is some trickiness about the transparency, potentially, right? Because if a justice reveals all the ways in great detail that there is a possible grounds for recusal, that potentially lays the ground for strategic behavior among litigants and law firms in order to engage in behavior to set up conflicts of interest to get justices anticipatorily off of cases.
No, that's an excellent point, and it's one of the reasons why the justices are reluctant to do as much as some might want them to do. I think that is a real concern that that there will be strategic behavior. There were 6.5 justices who said that they think the court should have a code of conduct. I don't think any of them have said exactly what that code of conduct should look like. Mm-hmm. And the area of recusals is actually a tough one.
Yeah.
Partly because of the reasons you just gave, and partly because at least the way things are set up now, there aren't any extra justices around. So if I'm a district judge and I recuse and another district judge steps up and takes my place, I mean, even in the and same is true on the courts of appeals. Even the state Supreme Court, the California Supreme Court, just for example, has 7 justices. If one of them recuses, then the chief designates usually one of the presiding justices from the courts of appeals, sit pro tem, and take the place of that justice. Well, there's no constitutional authority for that. So if a justice is recused, the court is smaller. An 8-member court or a 7-member court or a 6-member court, that's a different court. I mean, this is much literature on this. The addition or subtraction of a justice changes the court. Yeah. It changes the dynamics. It makes it harder for the court to get its work done. So I think when they get around to adopting a code of conduct, and I truly hope that they will, I think there's going to have to be some thought given to how recusals work.
Yeah.
And the proposal that we submitted has some suggestions there. But I think that is a real concern for them. And I think another concern along those lines is that, and I know for a fact that the justices who have so far been unwilling to go down that road, they're afraid that there's going to be frivolous complaints, that there are going to just be lots of people saying, you can't hear this case because you don't believe in my vision of the Constitution. And they worry about the administrative cost and the personal intrusion on their space that would be required to answer those kinds of things. And so, so there has to be some kind of screening built in as well, so that they're not spending all their time dealing with requests that they recuse.
Right, and presumably that would be, similar things happen with like cert petitions and stuff.
Exactly.
Anyone can file a cert petition.
Oh yeah, there's thousands of cert petitions, and they grant cert in about 50, 60 cases a year.
Right.
So I think they would need some sort of screening mechanism. But I think that is one of the things that the people who are reluctant to adopt a code will raise in conversation, is that there's going to be all of these meritless complaints.
Yeah, and maybe if we could just circle back, I would love to hear you talk. You mentioned briefly, the crisis in the courts, and just how significant do you think this is to some pretty bedrock principles about our democracy and the rule of law?
I think it's really significant, I've got to say. I think probably if you try to deconstruct people's lack of confidence in the courts, most of it would have to do with the decisions. People being unhappy with the way X case was decided. But then it's not just a additive effect, it's a synergistic effect. If you get cases that go that are sort of significant departures from the way things have been. That could be abortion rights, it could be religious liberty, it could be a bunch of different things. When you get those kinds of significant changes, which we've seen because it's a very, and I'm not using this critically and just being descriptive, it's a very activist court. I mean, there's a lot of significant change happening in the decisions. And there's people who think the decisions are great, and there's people who think the decisions are terrible. But then when you add to that the absence of any ethical standards that anybody can point to, I think it's a synergistic effect. You kind of get this idea, well, these justices are lawless. They just, I've heard the court described as the YOLO court. You only live once. If that's true, that is not what the rule of law is about, right? It's not about, well, we've got the votes now, so we're just going to do whatever we want. I have said I don't think that that's what's going on, but it's hard to make that argument when you don't have code of conduct.
Right. Well, I want to start turning to some questions that we've received, and this one comes from someone who submitted this in advance. Why do you think, I guess, and this might be unfair speculation, but how is it that in light of all the concerns that you've raised, that we've seen some of the behavior that we have, and that those individuals who have done those things that at least raised eyebrows, that they were unable to see the ways in which it might undermine the court?
That's a tricky question since I am deeply committed to nonpartisanship.
Yeah, sure.
But I will say, people are different, right? And so the lens through which each of us sees things is obviously it's shaped by our life experience. And I think sometimes people have a sense of grievance, a sense that the world that they want and they believe in is not being realized, or it's being weakened, or it's being destroyed. And so they see these kinds of discussions of ethics and so forth is really not what it's all about. And maybe I can sort of distract or deflect from this a little bit to something I saw when I was at the Senate Judiciary Committee. So at that hearing, the Democrats were raising the issues of, and really they were talking about Justice Thomas and Justice Alito. That's who they were talking about, and they were bringing those issues up. And the Republican members of the committee, pretty much without exception, there were a couple of exceptions, but pretty much said this is all sour grapes because you didn't like the way that Dobbs was decided, or you didn't like the way religious freedom cases were decided. That it immediately was seen through this lens of partisanship, and that you're not really concerned about these alleged ethical lapses as much as you're concerned about the jurisprudence of these justices. So, and that was it was very frustrating hearing in that sense, because the electeds, that's what they wanted to talk about, pretty much without exception. I think the justices, being human beings, can't help having some of that, right? I'm being targeted, I'm being singled out because I've been forthright about my principles, and I think people could look at that and say, well, I just disagree with that. I don't think that's what's going on. But yes, what are they thinking? What's in their minds?
Yeah.
And I think that maybe their sense of what's an ethical breach is affected by what I was just trying to describe.
Yeah. And I everyone, this is me speaking and not the judge. I will just say, having listened to some speeches by Supreme Court justices recently, and I will just pick one, Justice Alito's speech at the Federalist Society. There is he has a remarkable sense of grievance about a number of issues. I'm not sure exactly where that comes from, but it definitely is part of his persona that's very evident when he speaks publicly about a lot of issues, particularly religious liberty. So again, that's me. I'm just going to say
because the justices are people,
Yeah.
I think we shouldn't like idealize stuff. I mean, they're people, right? And every one of them has his or her own values and background, and to me this all circles back to why we should have a code of conduct, because then at least, okay, here is a set of principles everybody has signed off on. And this gets to a question you haven't asked, but I've been asked a lot, which is, if 7 of the justices want to do it, which is kind of my sense of where things stand, I mean, how come they don't just do it? And I think part of it is, and I'm channeling the Chief Justice here rather than repeating anything I've heard him say, I think he thinks it's important that it be something they've all agreed to.
Yeah.
Right? I mean, that there's real value in consensus, and it's not just a make nice thing. It really is saying this is the standard that we are willing to all live by.
Right.
And that there's real value. And I have to say, I think it would be so much more powerful if all 9 of them did it. And I hope that they will. I mean, I am skeptical at this point, but I just think that it would be a much more powerful statement than to say, well, 7 of the justices think that this code is okay. I mean, I think it's throwing the other 2 under the bus, and it's really, in a way, it's kind of making partisan something that really absolutely can't be partisan. It seems to me ethics is not partisan. I mean, ethics is a matter of core principle.
Sure. Yeah, and I know through various sources, people I know, that through another thing that should also be nonpartisan, which was the leak investigation. Relationships are just very fraught inside.
No, it's
right?
absolutely true. I mean, I think that was incredibly destructive, and people suspect each other literally. I mean, we don't know whether it was a clerk or a staff person or a justice or a spouse of a justice. I mean, I've heard theories on all of these directions, and the point is, since we don't know, then it's another thing. Whenever you have doubt and you don't have transparency, whatever your biases or your prejudices in terms of politics and partisanship, they can get attached. Well, of course it was Mrs. Thomas, or of course it was a left-wing law clerk who wanted to embarrass Justice Alito. It's like, and so you hear these theories, and we don't know if any of them are true. Right. We just believe what we want to.
Right. This is a question from the audience, wondering if you could shed some comparative lens on this. Are we unique? Do the other highest courts in other democracies have a judicial ethics code that our highest court lives?
Yeah, I mean, to my knowledge, and I can't speak to every country in the world, but the countries I've visited, and where I've gotten to know people who are in that place. Yeah, I mean, the UK or Ireland or India or Pakistan. I mean, the common law countries, there's a pretty strong sense, and I mean, it's detour for a second. I mean, like India and Pakistan are both countries that have had, lots of turmoil politically and lots of upset. The judiciary has sort of been a shining light in those countries. That the judges are very, very dedicated to the rule of law and to ethics, and they've had remarkably few ethical problems.
So I'm just going to start reading these because I can't digest them all while we're in conversation. Is there a statutory or regulatory guidance for evaluating a Supreme Court nominee's ethical fortitude during their confirmation hearings?
Well, not a statute, but it's a really good idea. I mean, I think it's a kind of thing that I suspect in future confirmations, somebody's going to ask those questions, and they should.
Yeah.
I think part of this problem, part of this larger institutional problem we have, is the confirmation process. And I'm not sure how we fix that, because it is so political. I mean, there are massive campaigns, pro and con, whoever's nominated. It's like major. It's like a political campaign, and the vetting, the pre-vetting of nominees that's done, whether it be Federal Society or American Constitution Society, or somebody doing the ideological vetting to make sure that the person is trustworthy, right? And then you have these campaigns, and so the confirmation process, and a friend of mine described it very well, it's kabuki theater. You just, it's all, it's done. And that's why you get these really strange situations where like stuff comes up at the last minute, right? Justice Kavanaugh's, the accusations against it's like what we got to come up with something because the cake is baked, right? And I think if you start back at the beginning with looking at ethics as part of the vetting of the suitability of a nominee, I mean I think that's a positive thing.
Circling back to something we touched on before, but I think from this question is not entirely clear. So you think the Supreme Court could have an ethics code that it could impose on itself there would be no constitutional problems with that, and we wouldn't need any amendment to the Constitution or anything in order to achieve something, and that would be meaningful even though the court is imposing it on itself?
I think it would be very meaningful because it would be recognition by the court that this is important. And actually, if you look at the statements of the justices who've actually gone on the record on this, that's what they've said. Justice Barrett said that when she was in Minnesota. Justice Kagan said that when she spoke with the Ninth Circuit this summer. Justice Kavanaugh said it. I mean, they all use essentially those words. It's a gesture to the public saying, we really do care about ethics. And here are the rules we're committing ourselves to follow. Now, whether they follow them or not, I mean, I got to say, I think we have an extraordinarily ethical federal judiciary, and I've been around it a lot. And very few instances of judges really going offline with unethical behavior, and we're really fortunate. I mean, people look to us. I mean, we're not beacon for the world in every respect, but this is one where we are, I think. So I think for the court to say, we're committed to this. And there may be disagreements about whether somebody should have recused in a particular case or whether something created an appearance of impropriety. The fact that you've actually agreed on a set of rules and you say, we're going to really do our best to follow these, that's better than what we got now. What we got now is trust us. How dare you question us? We're great people. We're really smart, and we got this black box of stuff we look at if we have an ethical problem. I mean, I just think even if they're wonderful people, if they're the 9 best people in the world, I mean, it'd be nice to have a structure that is a point of reference.
Okay. So this may be a different question, I acknowledge, and I'm sort of asking whether it is a different question. For those of you who don't follow the federal judiciary really carefully, there's a Court of Appeals judge on the federal circuit who is at a point that at least a number of people believe that she's no longer mentally capable of discharging her obligations in office. And there's been a big kerfuffle about what to do about that situation when she won't voluntarily step down from the bench. And so taking it away from that specific case and just sort of talking about the problem in the abstract that we're now at a point in human history where human beings live a lot longer than what the framers thought when they created life tenure. Would a code of conduct have anything to say about those sorts of situations?
In fact, I mean, I don't mind talking about Judge Newman. This is Judge Polly Newman on the Federal Circuit, who I'm very proud to say has been my friend for many years. She is 96 years old. Her colleagues believe, I think unanimously, that she is no longer able to discharge her duties in an appropriate way. She disagrees, okay? And that's getting litigated, literally, in the D.C. Circuit, and there's proceedings. But with regard to those things, there are rules. There are frames of reference. There are precedents, that these are the things we expect of judges to be able to do. And so the yardstick for Judge Newman is not going to be, is she with it or not, or is she suffering from any kind of cognitive decline. It's going to be, can she do these things? Can she discharge her duties in a timely manner? Can she treat staff with courtesy and respect and patience? Can she work with colleagues in a collegially. All of this stuff is either written down in the code of conduct that applies to Court of Appeals judges, or it's in the penumbra. It's in the interpretations of the canons. So you have a body of law, or at least you have a body of guidance that you can look at in this case. And so it's not about, do you like Judge Newman or not? I mean, I love Judge Newman, so it's got nothing to do with that. It has to do with, is she getting her work done? And you have measures that you can look at. We don't have that as a Supreme Court. We don't have anything, And again, so in the absence of that, what you have is, well, I like Justice Thomas's decisions, or I like Justice Kagan's decisions, and I think that's why the absence of code of conduct is a problem.
Yeah, and we did have that. I mean, we had that very problem. I've read about it a little, but with Justice Douglas, that was very much a problem at the very end.
Absolutely.
And there was no easy solution.
No, it was really embarrassing. I mean, for those who don't remember that history, I mean, he stepped down from the court, and then he kept coming back.
Yeah.
And he wanted to sit on cases. I mean, it was beyond any kind of defensible thing. But there was no procedure in place, for dealing with that.
Yeah. Another question from the audience, which is how this intersects at all with expanding the court and whether that would help in some way with these issues.
So these are interesting because they also get refracted through partisan lenses. So the two things that have been suggested are expanding the court and term limits. Expanding the court, I mean, to me, if you look at it just from an academic perspective, I mean, there's some pretty strong arguments that you look at all the other industrial countries in the world, our sort of our peer nations, they don't have 9-member Supreme Courts. I mean, they have big Supreme Courts. They have at least, Canada's got 15, and India has dozens of judges on their Supreme Court. I mean, when you have 9 in a country with 350 million people, those people have extraordinary power, and they have life tenure, and they're getting appointed when they're 10 years old now. And it's just kind of, you're giving those 9 people an enormous amount of power, which is why millions and millions of dollars are spent on every confirmation. And so it just creates a process that is I think, is toxic. So, if you had 25 justices, it's not that those appointments wouldn't matter, because they do, and they still would, but they wouldn't matter as much. So there's that idea.
And that would be, just to interject, and that would be, you still have maybe a random draw of 9 out of the 25.
Exactly.
So you wouldn't be able to know on a case-by-case basis.
Exactly. They wouldn't all hear everything.
Yeah.
The problem with expanding the court is political. It's assuming you could ever get Congress to think about it. How would you set it up so that President X didn't appoint all the new justices? You'd have to figure out some way to make it not be a partisan power grab, right? I mean, how do you just say, well, we're going to have 10 new justices, 5 of them have to be Republican, have to be Democrats, or some way of making it, getting the politics out of it. But that's a pretty tall order. I mean, that's really hard. So that's the problem with expansion. And let's say that one side did have enough strength in Congress to do it. They could do it, and then as soon as they lost power and the other side came in, they could undo it, or they could expand it again and add their own people. So it's like that's the problem with that. I'm in the group of people who think the term limits actually are a good idea. I think that what's been supported most often is the 18-year term, and then staggering it so that each presidential term would have at least 2 appointments, and you could still appoint young people, who at every conference would serve the 18 years, but you would guarantee turnover, and you would avoid some of the problems of people being on the court for a generation, and getting the kind of the generational disconnect that sometimes you have. One of the issues with term limits is, can you do it without amending the Constitution? I think there's a growing body of legal authority that you could. The judges get life appointments. You can't diminish their life tenure, because that is in the Constitution, but it doesn't say they have to be on the Supreme Court all the time. So, you could appoint somebody to an 18-year term, after which they would become a senior judge, and they could, sit on assignment in circuits, or they could fill in on recusals. They wouldn't be on the en banc panel, but they would be available in a recusal situation. So I think there may be a way to do it that is constitutional. Again, I'm not sure there's a political will, but in theory, term limits don't strike me as being partisan. If people look at it in the short term, say you like the conservative court, well, this court is likely to be conservative for a long time, so there wouldn't be the same impetus to change it that there would be if you were on the liberal side.
Yeah.
But I think from a more just to look into sort of the abstract merits of it, I think it's hard to argue against term limits.
Yeah.
I like term limits.
Yeah. I mean, one thing that has occurred to me, and I think of an expert panel just released a report, was it earlier this week, that a bunch of really smart people proposed that. But given how things have gone recently with the Garland nomination and everything, is that if the Senate is of a different party of the president, then even if the president supposedly gets to, how do you make sure that those appointments actually get on the court?
You don't.
Yeah.
I mean that gets back to the brokenness of the nomination process.
Yeah.
But political compromises used to get made. I mean, we used to have more of an appetite for those kinds of things than we do now. So.
All right. What is the ideal character of a judge, someone asked? Who has influenced Judge Fogel in that regard?
Well, that's a great question. I love talking about that. So, I just did a training yesterday for some mentors of judges, and I opened up the training by saying, well, who are your mentors? I mean, who inspired you? So the story I have always told is, so I was a mental health advocate before I was a judge. I had an unusual legal background. And my clients, were difficult people. I mean, they were delusional, or they were emotionally labile is a term. They would kind of just unpredictably go off and lose it. And I had to represent them in legal proceedings. And so in dealing with judges, I had some good role models and some bad role models. Right? I mean, there were judges who were rude, who were impatient, who were just very disrespectful, and that kind of set a certain point in my thinking. And then there were some judges who were great. They really got that the part of the job is you treat people respectfully. That when people come to court, it's their life. Usually it's a very important matter in their life, and they want to be listened to. They want to be treated respectfully. They want to be heard. They want to feel like they're going to get a fair shake. So I had a couple of inspirations in that. One of them, I think, is well known to people in this room, William Ingram, who was judge of the Superior Court and the District Court. He was his chambers were right next to mine near the end of his life, so we talked a lot. I mean, he was just somebody who just knew how to treat people. And I think his temperament was really the thing that was the biggest inspiration to me. I liked the way that he treated people. I remember when I was a young lawyer, and I had a case that was a difficult case, and I appeared before Judge Ingram. He was on the Superior Court then, and it's just I came out and said, "Wow, this is really cool." He didn't make me feel bad that I was a young lawyer. He didn't make me feel bad that I didn't know what I was doing. I mean, it was just he treated me the same way he treated everybody else, which was respectfully. So models like that, I think, really seeing judging done well, really was what kind of helped me set my sail.
Yeah. Well, that makes me think of another thing related to the Supreme Court. Do you think that the manner in which the justices have evolved in terms of how they handle oral argument, and I'm thinking of, I would say, I think it's accurate, objective to say, with a fair amount of sarcasm and with a fair amount of questions that are not motivated by genuine intellectual curiosity, but are motivated in order to use the lawyer as a vehicle for making a point to their colleagues. Do you think that has contributed to this problem of disrespect?
No, I think that's a problem. I do. I think some of the justices do that more than others. I'll just say it in this room. I mean, my point of reference on this court is Justice Kagan, because she has a sense of humor. She's really smart. One of the smartest people I've ever met. and she has a really good sense of humor. So she doesn't take herself too seriously, and even in these situations where these are significant issues, and I know that she feels very strongly about them, whether she's in dissent or whether she's in the majority. It doesn't take away from her ability to be a positive person and to find something. And she and Justice Scalia had a really good relationship, even though they disagreed about everything.
Yeah.
It was just because I think they respected each other's intellect, and so I think there's those kinds of qualities I think are salutary in Supreme Court justices, and not all of them have it.
Yeah. So do we have time for one more? Okay, so how can the Supreme Court moving forward overcome the idea that once you reach a certain level in a profession, you join, and this is in quotes, a club that consider yourself untouchable or that doesn't have to abide by the standard anymore? And I'll just add, how is it, because this is, dare I say, a dynamic within any profession in which people get tenure,
I hear it
get
happens,
life tenure, and they don't think of themselves as terribly accountable to other people.
The dean of my law school talks to me about this all the time.
How is it, and I think it's particularly, there's a particularly cloistered way, because once you become an Article III judge, as we were talking about before the event, there's a real limit on who you can associate with and talk to. How do you prevent that from becoming an echo chamber in which you don't see every criticism of you as simply sour grapes?
I think that's really hard, frankly. I think you have to have other people in your life. You have to have other centers of meaning. And the problem is that to be a high achiever, you end up. I've really seen this living in D.C. for the last 12 years. It's such a closed circle. I mean, there really is this inside the Beltway groupthink, and to sort of get out of it, you have to be intentional. You have to have other things in your life, and I think some people succeed at that. I mean, to me, Justice Sotomayor is a good example of that. That she makes a real concerted effort to be a human being. She lives in part of D.C., which is very humble, not humble, but at least not fancy. And she makes a point of really getting to know people and interacting with them personally. When she gives a speech, she likes to come down from the lectern and walk around. And, it's like there's just, and that's all intentional. It's not an accident.
Yeah.
So I think you have to really work at it as you get in these elite perches in our society. You have to really work at it.
I'm sure the U.S. Marshals really love her.
She's a challenge.
Yeah, I'm sure. I'm sure. Yeah. Well, let me just say thank you so much.
Thank you. Thank you. Great questions. Yeah. Thank you.
Thank you so much, Judge Fogel, Professor Jundev, for a wonderful conversation. Thanks so much to all of you listening online and everyone here. And please keep your eyes open for more great events coming from the Law School and the Ethics Center. So great to have you all here today.
Thank you so much.